Our purpose is to understand as much as we can about the state of the judiciary. We've asked Professor Hugh Corder, who I think will be familiar to almost all of you, to give us an overview from his perspective, to take into account also, to reach back into the past. Hugh did a lot of work on the bench during the apartheid era, and he's been observing it keenly in the democratic era. So we can do a little bit of comparative analysis, I suppose, and ask questions about how used it to be and how is it now, and so on. Alison and Mbekezeli both work for the organization Judges Matter. Alison is the coordinator, Mbekezeli is a researcher there. And they do a huge amount of work in monitoring the judiciary, monitoring the selection process at the Judicial Service Commission, keeping up with the, dare I say, growing number of scandals and upsets and controversies that are emerging, looking ahead to say, what do we need from our judiciary? What do we need from a new Chief Justice? And we will be getting a new Chief Justice towards the end of this year, and so on. The way that we're going to do this is that Hugh will start and give us a presentation. I've asked that it not be longer than 25 minutes. And then I will have a conversation with Alison and Mbekezeli about some of the points that we've just mentioned. So that'll be a bit more of a to and fro, and we'll keep that also to 25 minutes or less. With that, let me hand over now to Hugh Corder, and let's listen to Hugh's presentation.
Thank you very much, Chair, and thank you to the Catholic Liaison Office in Parliament for arranging this seminar, this webinar. At the time you heard, so this is extremely relevant and timely in my view. Thank you very much also for asking me to focus on, let's call it, the historical context as well as the lead up to the present. I have been focused on the work of the judiciary since 1978 with that brief overview of the past. And to say that with singular exceptions, the South African Superior Court Judiciary from the outset was complicit with white minority interests in this country. The bench was composed for a very long time exclusively of white male judges. At the time we moved to democracy in 1994, of the 160 odd judges on the Superior Court bench, 2 were not white and 2 were women. The rest were white males. There were some exceptional periods in the history of the Superior Court bench as a whole, when the judges didn't reach judgments which were wholly consonant with the interests of the white minority in Parliament. Immediately after Union in 1910, the judges, although they saw their role as nation building, nation in their terms meaning the Dutch-speaking and English-speaking white people, but they were also at that period intolerant of the development of executive discretion. So they, on a number of occasions, wrapped Parliament over the knuckles for giving too much power to the executive. That was, in fact, in line with judiciaries elsewhere in the British Empire at that point. Of course, also in the early 1950s, in the what became known as the coloured vote crisis, immediately after the accession to power of the apartheid government, the appellate division had a number of clashes with the legislative schemes of Parliament. Interestingly, if one looks back to the removal of black voters, black African voters from the common voters roll in the 1930s, the judiciary created no obstacles or interpreted the law so as to throw no obstacles in that legislative plan. But war, pandemic, and a universal trend to empower the executive branch over the course of the 20th century meant that by the mid-1960s, national party hegemony was reflected on the bench. By the 1980s and the states of emergency, which many of us can remember, the vast majority of the judiciary and the dominant trend in the appellate division was to be, as has been described, more executive-minded than the executive, perhaps. So the question has to be posed. Why have we assigned the courts such a central safeguarding role in our constitutional democracy? That there are two main reasons for this. At the outset, I said, firstly, that there were singular exceptions to the dominant judicial view under both colonialism and apartheid. These were cases in which judges were able and willing to exploit gaps and silences in the law and the ambiguity of language, relying often on common law values and the common law emphasis on justice and individual rights, both in the Roman Dutch law and in English law, to find for those who opposed apartheid or were being targeted by the regime. Yes, these judgments were not minority, but taken together with the leading role in the struggle of lawyers, and I'm going to mention a few, Mandela, Tambo, Pichi, Fisher, Mohammed, Kentridge, Bezos, Langa, Moseneke, Chaskelson, Sachs, Krichler, Goldstone, Didcot, and so on. I would argue that the ideal of social justice through government under law, or the rule of law, remained very much alive. So, just to repeat, despite the overwhelming identity with white minority interests in that period, 1910 to 1990, there were significant exceptions in judgments of the court, and any number of people were assisted against the depredations of the apartheid regime by court findings in their favor. The biggest, the most powerful resistance movement also frequently expressed its views in terms of written documents endorsing human rights. So I refer to the African claims of the ANC, of course, the Freedom Charter of the mid-1950s, and there were a number of NGOs which grew up, which were founded and developed in the late 70s and the early 80s, such as Lawyers for Human Rights, the Legal Resources Center, the Public Interest Law Firm Nardell, the Black Lawyers Association, etc., etc. These organizations functioned together with those significant lawyers I have mentioned. So taken together, I think this is the first reason why there were a degree of faith remained in the law. But secondly, the timing of our transition to democracy, together with the fall of the Berlin Wall, the disbandment of the authoritarian USSR, coincided with a massive constitutionalization of both Central and Eastern European countries, which were liberated from Soviet hegemony, and a renewal in Africa, particularly in the African Commonwealth countries, starting with Namibia, followed by us, and then in the 1990s and beyond, Uganda, Malawi, Kenya, etc., etc. In all of these, judicial review, faith was placed in judicial review of both executive action and legislative action. That's the second reason for me, the timing of our transition to democracy. So in the spirit of never again will there be a denial of basic rights. Never again will there be a tolerance of autocratic government. This spirit characterized the multi-party negotiating process and the work of the Constitutional Assembly. How has this been achieved in our Constitution? I would suggest through 5 primary building blocks. Firstly, a new understanding of the doctrine of a separation of powers. Each of the branches of government has clearly defined powers in the Constitution, and there is a clear understanding, even though that phrase separation of powers does not occur in our Constitution, the judgments of the Constitutional Court have found that it is there, and it depends upon a proper understanding of the limits of the authority of each branch of government, but most importantly, a mutual respect or deference. That word deference under apartheid, very often meant that judges had to defer to the executive. Under our Constitution, there must be a mutual deference, a mutual respect among the 3 branches of government. That's the first important point, the re-envisioning of the doctrine of the separation of powers. Secondly, we all know we have a written rigid Constitution with explicit value statements in Section 1. And I would particularly refer to Section 1D, which sets as a value the supremacy of the Constitution and the rule of law, and 1E, which refers to the multi-party democratic system of regular elections to achieve accountability, responsiveness, and openness. The third element, the third building block is, as I've referred to before, judicial review of legislative action. This is central to ensuring compliance by all of those who exercise public power, compliance with the Constitution. And together with that, we saw the establishment of the Constitutional Court and a new appointments mechanism through the Judicial Service Commission. The fourth element that I would refer to are a group of new procedural rights in the Bill of Rights in sections 32 to 34. The right of access to information, the right to administrative justice, and the right of access to court. Those who practiced law or studied law under apartheid will remember the infamous ouster clauses, whereby Parliament attempted to exclude the review power of the courts. The ouster clauses cannot, in plain terms, exist anymore lawfully because we have the right in Section 34 of access to court. And fifthly, the fact that our Constitution has a transformative agenda. Again, the word transformation does not occur in the Constitution, but it is in the very fabric, in the lifeblood of the Constitution. So those, I would argue, are the building blocks. And how has this worked out? I would say that it's worked out, as far as the judiciary is concerned, in its review power in 2 phases. The first phase, 1994 to 2008. Although there was some resistance from the old guard among the judiciary, centered in the appellate division, now the Supreme Court of Appeal, great leadership from Chief Justices Corbett, Mohammed Chaskelson, and Langa, and an astute balancing act by the Constitutional Court, packed with justices with a very nuanced sense of the limits of their authority, showing appropriate deference, the product of the decades of involvement in struggle politics or acting as representatives of opponents of apartheid. Worked together with a fearlessness in the exercise of their judicial review power. They were not scared at all to call out the executive and parliament, most notably in 1995, when they upset the arrangements for municipal elections in the Western Cape, and President Mandela was called to account on that occasion. And we will all remember the Treatment Action Campaign cases and the extent to which that set Parliament and the executive right. So I would say that that first period, 94 to 2008, was marked by a brilliant sense of balance being achieved, laying a foundation for the future. And then we moved to the period 2009 to 2018. This coincided with the Zuma presidency, and the court, led by the Constitutional Court, buoyed by the resolute and principled start in the first 15 years, the Constitutional Court showed impeccable courage and commitment to constitutional values and principles. As it was confronted by repeated and willful acts of executive and legislative delinquency, it kept true to its mandate. Many high courts followed suit, and we must never forget the work of the Supreme Court of Appeal, which has often been overlooked in its own resoluteness, I would argue, in its commitment to the values of the Constitution. The problem is, and it is a real problem, this commitment to principle and the appropriate role of the Constitutional Court and the judiciary more broadly comes at a price. And the price is overt hostility from the executive, from legislature, and from dominant political party leadership. I just want to read two quotes from, in fact, 2011 and then one from 2015. As follows: the day the judiciary tries to substitute itself into the principle of the people shall govern, it runs the risk of losing the respect of the people. There is no democratic order in some kind of country that is subjected to a judicial dictatorship. There is a coordinated liberal offensive by people who do not have power to seek to challenge almost any decision by the president and the executive. That was Minister Blade and Zimande in 2011. President Zuma in 2011, the powers conferred on the courts cannot be regarded as superior to the powers resulting from a mandate given by the people in a popular vote, and so on and so on. There were myriad such quotes at that point. So I think it's fair to say that what has happened in this country is both the legalization of politics and the politicization of the law. The legalization of politics occurs when political parties and organs of civil society resort to the courts, often, mostly, in total frustration at the lawlessness or the unlawfulness, rather, of actions of the executive and the legislature. That can lead, of course, it is argued, to the politicization of the law. That judges fall foul of the temptation to express their own political views, or what they deem to be the political views of the majority of the population, through their judgments. What is critical in this is that the courts have no army to summon in the enforcement of their judgments. They must work with the executive. And in order to retain their legitimacy, the courts must maintain the confidence of the large majority of the public. And I would argue that our courts have succeeded in doing that, particularly in this bleak period of the last 8 to 10 years. The courts have maintained popular legitimacy in support of some of their more controversial judgments. So how does the executive respond? The dominant party political leadership tries to bring the courts into line, in quotes. How do they do this? As we've seen, they do it by populist rhetoric, and we've seen a lot of it in the last couple of months. We've seen an allegation in evidence before the Zondo Commission of bribery, or attempted bribery of judges. There's been nothing to substantiate that has come into the public domain. But typically, the executive would seek to influence the process of appointment, not only to the High Court, but more particularly to the Constitutional Court and to offices of judicial leadership like the Chief Justiceship. The key institution here is the Judicial Service Commission. And I have to acknowledge that in an article published in 1992, I argued enormously strongly for the institution of a Judicial Service Commission. I would have constituted it differently from what it is today, but I think ultimately it is the right way to appoint judges. I would say broadly, and I'm going to be coming to an end, Mike, in case you're getting worried, I would say broadly on appointments, the Judicial Service Commission has done well. It's done well on demographic transformation of the judiciary. I must say, demographic transformation does not always coincide with ideological transformation and the other way around. But I would say that the JSC has broadly maintained the appointment of people to the High Court and Superior Court bench, people of integrity, people with good working habits, and people who enjoy, can be trusted, and who enjoy the support and legitimacy of the profession and the wider public. And we see an example in President Zuma's appointment of Chief Justice Mogoeng, of one which frankly probably backfired on President Zuma, contrary to his expectation, but this is reflective of patterns of appointment all over the world. Who are the key players in the JSC? It was significant for me. There are 4 presidential appointees on the JSC, and there are 8 or 9 party politicians. Together, that constitutes a majority of the JSC, which varies between 23 and 24 members. For me, it was highly significant. And one of the first presidential acts by President Zuma in mid-2008 was to fire, without notice to them, the 4 presidential appointees who had been appointed by President Mandela in 1994 and had remained throughout President Mbeke's 1 3/4 terms of office as the presidential appointees. They included George Bizos. But the members of parliament as well are a critical constituency, and we've seen varying patterns of behavior from the members of parliament, as well as a tendency to vote en bloc, particularly the representatives of the dominant party in parliament, the ANC. That's all I want to say on judicial appointments broadly. It is in the area, however, of judicial discipline, which is squarely part of the work of the JSC, that it has failed ignominiously from the beginning to the end. A structure for judicial discipline was only put in place legislatively with massive amendments and the addition of a new chapter to the JSC Act in 2008. We're now familiar with this. You get something called the Judicial Conduct Committee. That's the body which spoke yesterday on Chief Justice Mogoeng, and possibly the recommendation by the JCC of a JCT, the Judicial Conduct Tribunal, and we saw that in December last year in respect of Judge President Hlophe and his alleged misconduct in mid-2008. That 12-year gap exemplifies the paralysis of the JSC as far as judicial discipline is concerned. I would refer to the Matata matter and so on and so on. The delayed judgments issue, and there have been a couple of other smaller issues in relation to judges Maluleke and Parker. I want to leave further detailed comments to the judges matter participants, although I'm happy to comment at question time if necessary. Briefly then to the future, for me, what is critical will be to see how the JSC deals with both yesterday's recommendation in regard to the Chief Justice and his remarks on Israel, but also more importantly perhaps to the Hlophe matters which are not yet before the JSC, but which may well come to the JSC, because the JSC is the body which ultimately must recommend action or no action. In a sense, the JSC's decision will depend upon which faction comes out on top in the ANC. Secondly, I think it will be critical as to whom President Ramaphosa appoints to the 5 vacancies which will occur, some of which are already there too, in the Constitutional Court this year. That is almost half the number of judges on the bench. And if you just cast your mind back to some of the more extraordinary events during the Trump presidency in the United States, with that he managed to get 3 appointments to the Supreme Court, and they serve for life. Our judges on the Constitutional Court serve for 12 to 15 years. But there are going to be 5 vacancies this year. And then thirdly, critically, who gets appointed as the Chief Justice of South Africa at the latest by October. Let's see whether it is necessary to be earlier than that or not. Thank you, Chair. That's all I want to say. I hope that I haven't gone on over time.
No, I don't think you did. And thank you very much indeed, Hugh, for that, that great overview, reaching quite far back and bringing us right up to decisions, findings that were made yesterday by the Judicial Conduct Tribunal. Obviously, during the question time, we'll come back to some of the points that you made. I just wanted to flag one in particular. You say that you believe that the courts are still maintaining the confidence of the public and a sort of popular legitimacy. And when one sees the numbers of people that on occasion arrive at court in support of a Jacob Zuma or an Ace Magashule, for example, in a sense, prejudging the issue and claiming that such people are almost by definition innocent, and that the moves against them are purely political. One wonders a little bit how the courts are, in fact, whether the courts are in fact retaining as much popular legitimacy. In other words, whether their decisions, were they to go against a Zuma or a Magashule, for example, would be respected. But we'll come back to that question. Alison and Mbekezeli, if you would both unmute yourselves now, and we will have a conversation. Hugh brought us to the Judicial Service Commission, and as I said in the introduction, that is where Judges Matter does a lot of its work. You observe the selection process and the interview process of judges very, very carefully and closely at the JSC. And you also, of course, observe the disciplinary side of the JSC's activities. So may I ask you, first of all, and I don't mind which of you deals with the question, just to give, again, a brief overview for those who may not know of how the JSC goes about its process of receiving nominations and then making recommendations for the appointment of judges. Just in a nutshell, how does that work?
Okay, thanks, Mike, and thanks, Hugh, for that outline. Very briefly, how the JSC does appointments is that it calls for nominations or applications which people submit, and then it has what is called a shortlisting or a sifting committee. That committee assesses the candidates and then draws up a short list. Well, firstly, a long list, and then at a meeting of the JSC, a short list is then drawn up, and then it is then sent publicly. After that public shortlist, there will be comments that come from the organized legal profession and members of the public as well. Interviews are then held. Usually it's April and October of each year. And then those interviews are public, and that's where candidates get asked questions to assess their fitness. And then only after that process will the JSC make a recommendation to the president for a candidate to be appointed. So that's just the process in a nutshell.
And it's an open process. Anyone and everyone can pitch up there and watch the interviews, and I believe that they are also carried online in various ways.
Yes, the process is open. We try to live stream it every year, and we wish that more people would attend. But it seems that over the years, people do watch the interviews. In the time that Judges Matter has live streamed the interviews and published the interviews online on YouTube, over 1 million views of those videos have been viewed. So people are quite interested in the process. And the other difficulty, though, is that it's not so accessible. The interviews are in Midrand, and so not many people can pitch up there, but it is open nominally.
Alison, Hugh said that when it comes to the judicial discipline side of the JSC's activities, they have failed ignominiously in their mandate. Two-headed question, would you agree with that assessment? And can you actually name a disciplinary process which has run its course from initial complaint through to a final exoneration or recommendation of suspension? Has that happened yet?
Well, I think, I mean, ironically, the most recent example we have is the process involving the Chief Justice, where a complaint was laid and a decision has been made relatively quickly. So it is possible. I would agree without doubt with Hugh that the process is in general broken. And I think we have examples of where it's more broken than others. But I mean, there's been the issues that are ongoing now with complaints around Judge Goliath, Judge Mbekezeli, Judge Parker. There was a complaint against Judge Zondo, a complaint against Judge Davis, Judge Suriti. You know, there are, and even the process involving Judge Matata hasn't been completed. I think one of the things that we have been thinking about and trying to bring an analysis to bear that would help with reform is what is going wrong? Is it bad actors? Is it bad apples? And that's really the problem, and we need to just focus on taking out 2 or 3 people out of the system, and and then it will right itself. Or and I mean, it may not be an either or are there issues in the actual system of holding judges accountable that are the problem? And I think at this point we're probably arguing both. What I think we're definitely not saying is that there are a few rogue actors, and if they remove themselves or are removed from the system, that it'll go back to being fine. The process clearly takes way too long, and has many opportunities for questioning and taking things on appeal. One of the things Professor Corder said in an article he wrote on this question of judicial conduct is one of the qualities that we might need to look for in judges is that they will accept the decisions of their colleagues and their peers in order to make the system work. That if we're going to make the system work, we can't have each and every judge who is involved taking a Stalingrad approach, which of course you have to then balance with, judges have rights just like everybody else. So I think there's a number of interesting areas that we need to get into in terms of reform, reform has not been a particular characteristic of this Chief Justice's tenure. So perhaps we have to look forward to the next Chief Justice to really drive some kind of project that would deal with changing how things work.
The concept, and obviously it's a foundational concept of the independence of the judiciary, I would imagine that can sometimes sort of overflow into a feeling among individual judges that any outside judgment or decision about their conduct or what they may have said or done, position they may have taken, is a threat to that independence. And that it creates, if you like, a sort of insularity amongst individual judges. So it could be a difficult sort of balancing act there.
I think that's one of the interesting things about the JSC and their appointments process, is that this is something you really want to interrogate before you appoint a judge, as a judge. And I mean, I think Mbex has spent a while looking at those processes as well. And, you know, just in terms of the criteria that the JSC articulate and use, I think he may be able to speak to just how unclear those are.
Mbex?
So I just wanted to add something before I get to that question, Mike, was the idea of independence also needs to be looked at in two ways. I think it was Professor Kathy Powell from UCT who wrote about there is individual independence and then there's institutional independence. So the individual independence of a judge, that has to be protected, obviously, but you also have to consider the institutional independence of the judiciary. If there are bad actors within the judiciary and they are not held accountable, how does that impact on the institutional independence of the judiciary? So that's why it's so crucial to have a proper functioning conduct system, because it does not operate for its own sake, but it is to safeguard the independence and maintain the reputation of the judiciary, holding bad actors to account. And then on the second aspect, there is an issue in the way that the JSC assesses the fitness of a candidate to hold judicial office. We have argued, and the Judiciary in particular have made submissions about the criteria that is used. It seems as if over the years, all the way since Chief Justice Mohammed, there have been criteria that have been drawn up, but it seems as if they are not applied in the manner of questioning. You'll find that some candidates are asked certain questions, others are not asked other questions. The length of the interviews also varies. That speaks to that issue of criteria. And one of the things that we have been arguing for is that there should be some sort of a agreement that these are the qualities that we look out for. One of them is a person willing to subject themselves, for example, to the rules and the processes of the judiciary. One of the things that that was interesting in yesterday's decision from Judge Mujapile is that in his apology, the Chief Justice is required to explicitly say that he's willing to subject himself to the process of the Judicial Conduct Committee and the JSC Act, which is an interesting thing to note. It is an issue that should be assessed at the appointment stage, but it particularly becomes relevant at the conduct and disciplinary stage.
Do you see too much politicization of the JSC and its selection process? As Hugh pointed out, roughly half of the membership are political role players, office bearers, members of parliament, minister of justice, etc., and then the presidential appointees. Do you think that the composition of the JSC needs to be changed?
Well, the short answer is yes. The composition does need to be tweaked a little bit. The JSC does tend sometimes to be a bit too large, and some have argued that it should be reduced. But the question of whether or not it is too politicized is a question that I think Hugh, when he mentions the 1992 paper about the composition, is that you do want to have a role that members of parliament play in the appointment of judges. You do, that brings a little bit of the legitimacy that you need if public representatives are involved in that process. So having members of parliament is not inherently a problem. And then the four presidential appointments, they can be put to good use. There is a risk that the president's appointees can be political players and play an oversized role in the JSC. But in the past, as we've seen, President Mandela appointing Advocate George Bizos, President Ramaphosa most recently, he also appointed practicing lawyers, and even President Zuma appointed practicing lawyers in that role. So there is a balance to be struck between the lawyers and the politicians on the JSC. It's just a question of where that balance needs to be struck. In the past, I would say pre-2015, it was extremely politicized. We could see it in the manner of questioning from the Justice Minister, some of the members of Parliament. You could see the the internal ANC factional battles playing out themselves in the JSC. That has sort of tempered a bit in recent years, where you've seen sort of a easing of, there are politics involved, obviously, but there seems to be some sort of balance if you see the role that a politician like Julius Malema plays on the JSC versus the ANC politicians. So there are politics involved. It's just a question of where the balance should be struck, and perhaps it's a question of how the JSC is structured.
Thank you. I want to move to away from the JSC for a moment. We are seeing more and more veiled threats, warnings, etc., being issued to the judiciary. You mentioned Julius Malema. From the safety of Parliament a couple of weeks ago, he warned that there was the possibility of an uprising against the judiciary if it continued to give decisions that didn't meet with widespread approval and so on. It was kind of vague, but that's what we're used to. We've seen, as Hugh mentioned, these unsubstantiated claims of bribes being given to certain judges to return verdicts unfavorable to some politicians. Jesse Duarte, for example, published an article which was highly critical on a fairly personal level of Judge Zondo, and then a couple of days later, of course, she had to retract that. But Tabini Dlamini has said that the best judges are those that listen to the people, and I'm not quite sure what that means. But are we dealing with just a few isolated, sort of spontaneous outbursts from frustrated politicians, or can we discern some sort of a trend? And if we do, is it serious enough to be of concern, Alison?
I think there has always been a group of politicians that are deeply suspicious of the courts. And I think that has come out in rhetoric under different administrations over time. I suppose the question we're really asking is it getting better or is it getting worse? And it does seem right now that it is particularly bad. One of the reasons it is particularly bad and is difficult to deal with is that there are all of these allegations being made and that they're not being dealt with. So, for example, the question about Judge Hlophe and Judge President Hlophe and his most recent decision around the Member of Parliament. The fact that the system has not dealt with the many issues that Judge Hlophe has, attracted, can only mean that in this situation, the system is less robust than it should be.
Yeah.
Because it has not been able to deal expeditiously with those complaints. If there was, at this point, only 1 or 2 issues that the judiciary were dealing with, and then perhaps a third one was added, which was an allegation around a bribe, and the JSC was then immediately responding to that by saying, you know, those people who wish to lay a complaint or have evidence, please come forward. You know, we do not believe anything of the sort has happened, but, you know, we urge people to come clean and tell us if things like this have been happening. You know, if there had been a robust response, I think we would at this point be better off. Whereas right now, I feel like both the judiciary and in some ways the legal profession, people who want to uphold the rule of law and respect for the judiciary, are on the back foot. And you know, not exactly being able to defend a good position. I feel if we'd managed to resolve many of these conduct issues, we would be fighting an easier battle in order to, you know, uphold the integrity of the judiciary.
If the judiciary's own house was completely in order, then it would be easier for it to defend itself and for civil society to come to its defense. Yeah,
Precisely.
I think we should note that certainly after some of the more, some of the stronger remarks that were made by some of the politicians, I think after Malema's remarks, for example, the General Counsel of the Bar and 1 or 2 other professional associations did release very strong statements in support of the judiciary and the constitutional mandate of the judiciary. So, but I take your point. I also wanted just to make the point that we highlight certain individual judges around whom there have been problems, and in Shlope's case, long-term problems. But there are, what, 250, 260 active permanent judges in the country, the vast majority of whom get on and do their work, by all accounts, very well and without controversy.
268 at the last count that I have, and who are doing their work, you know, every day under difficult circumstances. I think with COVID, you know, everything has become harder, and dealing with infrastructure that isn't ideal. You know, the institutional separation of the judiciary from the Department of Justice is something has been an ongoing process. That process kind of stalled in 2012. It's not been something that the current Chief Justice has really had much appetite for, but there is potentially, there are potentially solutions there to some of the more practical infrastructural problems that the judges are facing. So I think whichever way we come at it, there really is an argument for reform, and I certainly hope the new Chief Justice will have an appetite for that kind of work, because it does seem to be needed.
Well, that's a nice lead into what was going to be my last question before we open it up for discussion. As we said at the beginning of the meeting, I think it's in October this year, current Chief Justice's term comes to an end. So by the end of the year, we need to have a new one. And Judges Matter published a number of articles on the Daily Maverick, I think towards the end of last year, which you looked at some of the criteria. You made certain suggestions of the sort of person that is needed. You even floated the names of a variety of potential candidates. So if you'd like to wrap up maybe by just giving us a synopsis of that. What is the kind of person that we need as a new Chief Justice, in your opinions? And if you feel that you'd like to put some names out there, feel free. Mbex?
Well, Mike, I will not mention names, but I will certainly speak about the kind of Chief Justice that we need. So last year we started thinking about exactly the kind of Chief Justice that we need. And we looked at, firstly, the role of the Chief Justice. And what we saw over the years is that the role of the Chief Justice has actually grown in terms of the responsibilities that the Chief Justice is responsible for, the prominence and the stature, if you will, of the Chief Justice has become extremely important. And one of the things that we've noticed, and I think Alison spoke about this just now, about that the idea was that it was a project that was initiated by Chief Justice Charles Kassin, but pushed quite strongly by Chief Justice Ngobo, was an idea of judiciary-led administration, where the judges or the judiciary runs the courts. That is a project that was started. The Office of the Chief Justice was meant to be that system, but it has stalled. And part of what the new Chief Justice will be responsible for is driving that project to completion, making it clear what the roles and functions of the judiciary versus the ministry or the Department of Justice will be. And so looking at and there's also the role of the Chief Justice now also involves a component that you're running the systems of appointment. The Chief Justice chairs the Judicial Service Commission and has to be responsible for developing policies relating to those systems, relating to the conduct system. So there is a policy-making function there as well. So considering all of these many responsibilities that the Chief Justice now has, what kind of criteria do you look out for when appointing a Chief Justice? And we've tried to sort of draw out some of the important qualities. One of them is intellectual leadership. You have, as a Chief Justice, they're the head of the judiciary, but also the head of the Constitutional Court, or the leader of the Constitutional Court. They set the law, basically, and drive the jurisprudence of South Africa. So you need a judge who will be respected by the legal profession, by fellow judges, who writes, who reads, who is able to demonstrate a excellence in his judicial ability. Mm-hmm. And then we've also teased out other qualities like management and administrative skill, considering that you now will be responsible for this judiciary-led administration. Are you a manager? Are you a leader? Are you able to administer systems and make sure that they operate in the way that they should? We've also highlighted issues of that the Chief Justice must be a communicator and a diplomat of sorts. They must be able to speak quite confidently on behalf of the judiciary, must be able to speak within the judiciary and bring all the judges along, all the officials along, in making sure that they achieve the idea of a quality justice. And there's also an international component. Chief Justice Mogoeng was quite active in the international scene, and the new Chief Justice might also want to play a role there. So there is a level of diplomacy that is involved. And then lastly, and this should probably be obvious, but the integrity, the reputation and standing of the Chief Justice must be beyond any question. We should all be confident that the person who represents the judiciary must be someone of impeccable quality and integrity. And those are some of the qualities that we've highlighted. Of course, there are many more, and we could unpack them later, but those are some of the things that we've highlighted. And with those in mind, we try to then think of where could the Chief Justice candidate be drawn from. We've tried to look at the heads of courts, so the judges, presidents at different divisions, and we've tried to highlight candidates from there. We've tried to look at the Constitutional Court, for example, who could be the next Chief Justice from the Constitutional Court. And then the question of a woman Chief Justice, we've never had a woman Chief Justice in South Africa. If we're looking at women judges, who could be the next Chief Justice for that? And then we've drawn up some candidates from there. So we approach it from a qualities perspective, and then the quality should then inform who the candidate is.